Good day to all of our law students across the Philippines. This is Hannah Longtong from the PUP College of Law, and I would like to welcome everybody to Central Book's Best Pre-Week Ever Bar Lecture Series 2025. Just a short introduction, this is the best pre-week ever bar lecture series from Central Books, the home of the best legal minds. Our lecture for today is just one of the many lectures we prepared for you, as we also have one for criminal law, remedial law, legal and judicial ethics with practical exercises, and lastly, taxation law. So make sure to like and follow the Facebook page of Central Books to make sure that you guys are updated on the dates and speakers of each program. We would also like to recognize our main sponsors for this initiative, Central Books and Rex Education. I want to extend our heartfelt gratitude for your generous sponsorship. So thank you so much. Now for the main event, I would like to introduce our lecturer for political law. Dean Libiran is a dedicated and an accomplished figure in the field of law. Hailing from Baguio City, his illustrious career spans across various facets of legal academia and professional engagements, making him a true authority in his field. Currently serving as the Dean of the School of Law at the University of Baguio, Dean Libiran also holds key roles as a Board of Trustee member at the Philippine Association of Law Schools and as a professor of law within his alma mater. His expertise extends to several specialized areas, including political and public international law, natural resources and environmental law, constitutional law, international law, and indigenous peoples' law. Dean Libiran is not only a sought-after bar reviewer, but also a respected lecturer in mandatory continuing legal education, or the MCLE. His contributions to the legal profession are underscored by his membership in prestigious bodies, such as the Singapore Institute of Arbitrators, and his advisory role on the Philippine Military Academy Board of Advisors. Among his many achievements, Dean Libiran has represented the Philippines on international platforms, including as a delegate to the 21st International Informal Seminar on Human Rights and Climate Change in Luxembourg, and as a negotiator to the Convention on Biological Diversity in Montreal, Canada. With his wealth of knowledge and extensive experience, Dean Libiran continues to shape the future of law through his teaching, research, and consultancy work. Please join me in welcoming our lecturer for political law, Dean Libiran.
Hey, good day, friends. So we will do political and public international law review. These are select questions, but we will expound them so that you will be able to understand and answer them, no matter how the question is phrased. So let's start with something that's always asked in the bar exams: amendment and revision. And here, I put here a tip. Whenever you're confronted with a question on amendment and revision, what you need to do is to distinguish between amendment and revision and to know the procedure. I'm saying this because, for example, in this 2017 bar question, the call is, what are the methods of amending the Constitution? So it requires you to explain briefly each method. Now, the facts here says that they wanted to change the form of government from unitary to federal. Now, to do that, right now we are in a unitary government, and to change from that to federal, do you think that is an amendment or a revision? So obviously that is a revision, because it does not only change a particular portion or provision in the Constitution, but it will change a lot of the parts of the Constitution. In fact, it will overhaul the Constitution, because a unitary system is one where sovereignty is concentrated in a central government, whereas a federal government is one where there is a central government and power is distributed to provinces or mini states. Okay, so the reason why I said a while ago that you need to distinguish is because the Constitution used specific words to determine and to recommend which proposals you can use to amend or to revise. Here in section 1, it says any amendment to or revision of, meaning you can use these two modes of proposal to amend and to revise. So the first one is a constituent assembly, where Congress itself constitutes themselves as the one who will make the charter change. And the second one is a constitutional convention. So both modes here of proposing can be used to amend or to revise. But in section 2, if you notice here, that's why I highlighted here the word amendment. Section 2 does not say amendment to or revision of. It's specific to amendment, meaning the power of initiative can only be used to make amendments to the Constitution. It cannot be used to revise the Constitution. Now, going back to the 2017 bar question, it says, what are the modes of amending the Constitution? And therefore, we can use the three: Constituent Assembly, Constitutional Convention, and initiative. Okay? Now, I'm sure you've read already the case of Lambino versus Comelec, where the court there said that the power of initiative cannot be used, or is insufficient to be used to make revisions to the Constitution. In that same case, they also wanted to revise the Constitution. Okay, a similar question was asked in 2019. So there's another proposal to change the Constitution, but what they want to do is to change the phrase, the Philippines is a democratic and republican state, into the Philippines is a democratic and a socialist state. Now, you know the difference between a republican state and a socialist state. A republican state is one where, you know, I think the more popular quote that you can use there is government of the people, by the people, and for the people, meaning the people themselves constitute government, but they elect representatives who will run the government. Whereas in a socialist state, it is ruled by a single party, and what happens in a socialist state is that party, the ruling party, has control over the resources. Okay, and so in this particular change that they want to effect, is it an amendment or a revision? Now, take note that a while ago we defined amendment as piecemeal. But is it really piecemeal? So if you think about it, they will only change that particular text. The Philippines is a democratic and republican state. But changing the word republican to socialist will entail a lot of changes in the Constitution. Will not be an amendment only, but will be a revision, because it will overhaul or rewrite the entire instrument. Okay? For one, you'll have to change the provisions on the thing that makes the state a democracy. You will have to change the interplay of the legislative, judiciary, and the executive branch. So that is not merely an amendment, even if seemingly it changes only a single word. Okay? So the thing to remember here is, will it entail a lot of changes in the Constitution also? So in this case, it is a revision. Okay. And then there's a follow-up question in that the same set of facts. It says, briefly explain the process to revise the 1987 Constitution. Now, you see here that they really want you to memorize the processes involved here, but there are only two processes. The first one is the proposal phase and then the ratification phase. We talked about the proposal phase, where you can have a constituent assembly, a constitutional commission, or you will have the people exercising their power of initiative. Now, in all of this, you can only ratify it through a plebiscite. But the difference is, if you go by initiative, aside from a plebiscite, you still need to determine whether the petition is sufficient through a COMELEC certification to that effect. Okay? But look at this question here. So if we go back to the question, paragraph B, briefly explain the process to revise the 1987 Constitution. That's why I highlighted initiative here, because we don't include that if this is the question. Remember a while ago I said there's a different manner to make proposals to amend and another to revise. We said that you can use all three proposals to amend, but only CONAS and CONCON can be used to revise. Okay? Now, I mentioned that the Constitution used very specific words. So if we examine section 4 here, look at it again. It says any amendment to or revision. Section 4 again used those two, amendment and or revision. But then if you look at paragraph 2, it only talks about any amendment under section 2. Okay, so that's how you ratify them. I underlined it. Ratified by a majority of the votes. But for initiative, you need to ratify by a majority of the votes cast in a plebiscite, but only after a certification by the COMELEC that the petition for initiative was sufficient. Okay. So let's proceed to some concepts in under principles and state policies. In 1996, they asked this question. So it's an executive agreement entered into by the Philippines and other ASEAN states. And the agreement is for them to send a battalion-sized unit of their own armed forces to do military exercises. So a group of citizens sought to stop that, saying that in the 1987 Constitution, this is not allowed because the foreign troops will have to be stationed in the Philippines. This question wants you to decide the attack on the constitutionality of the executive agreement. Now, before you will be able to jump into what black letter law to use, you need to determine first the difference between an executive agreement and a treaty. I'm saying that because the Constitution is explicit. Okay? It says that when or after the expiration of the agreement, for the use of U.S. bases in the Philippines, foreign military bases, troops, or facilities shall not be allowed in the country except under a treaty. That's why. But in this set of facts, they're talking about only an executive agreement, not a treaty. So I came up here with a table just so you can see the illustration of the difference. So a treaty example would be your mutual defense treaty or your visiting forces agreement. Whereas an executive agreement, example would be the EDCA. That's why the Supreme Court said the EDCA is valid, because it is only an executive agreement. It does not need Senate concurrence. Okay, so the major difference is on the purpose. For a treaty, you talk about policies. They are more or less permanent, whereas for executive agreement, these are merely administrative matters, operational, and normally temporary arrangements. So for treaty, obviously, you need Senate concurrence, but for executive agreement, you do not need Senate concurrence. So in this case, in the 1996 bar, we have to rule in favor of the concerned citizens because this is not a matter of administrative or temporary arrangement, but a policy. Okay, this is something that will have permanent consequences. And so that is not allowed. But since we're here already, I want to discuss with you that the president is the sole author, okay, the sole architect of foreign relations. And while there is a requirement in our constitution for Senate concurrence, do not make that mistake of saying that ratification is a function of Senate. That's not true. Remember, the word that they used is concurrence, right? So when you concur, means to say that you are agreeing, which means to say that the president had already ratified it, but the Senate has to agree. Okay? So that is a rule in public international law. International relations, diplomatic relations, these are within the domain of the executive branch solely. Okay. Another question that's always asked in the bar, but you will see that they're being more creative in how they phrase this question. But in 2017, it's quite straightforward. The only question is, what do you understand by state immunity from suit? Okay, and the Constitution doesn't really help. It just says the state may not be sued without its consent, right? And what is the idea behind that? Because it is the state. If the state will have to parry, will have to defend itself every time, every day, a lot of us would like to sue the state every minute of every day, right? And if that is the only thing that the government will do, then it will be very detrimental to the performance of its functions. Can you imagine? Instead of doing delivery of basic services and all governmental functions, it will just be in court defending itself. And so that is the rationale. And unless it consents to the suit, you may not sue the state. But how is consent given? How is consent given? Is it in the form of a note? Is it in the form of an executive order? Okay. To know that, we have to distinguish how consent is given. First, whether it was given expressly or impliedly. When it is an express consent, you find it via a statute or a law. So a general law that says that you can sue, or through a special law. You know the difference, right? So how does the state give its consent? Not through an administrative order, not through an executive fiat, but by law. Okay, express waiver of the right of its immunity against suit is given only via a statute or a law. But there are also some instances when the state is deemed to have waived its immunity, as when it enters into a purely commercial contract, right? Because in you know that government can function in the performance of its sovereign powers, right? Iure imperi, but it also has powers to pursue commercial interest, or in its iure gestionis function. All right. And the second way to impliedly waive immunity is when it initiates litigation and therefore exposes itself to counterclaims. Okay. Now, I guess the question we have to ask is, when does it become a suit against the state? So it is a suit against the state if we see any of this. For example, does it involve the property, the rights, or the interests of the state? If the answer is yes, then it is a suit against the state. But sometimes the cases implead public officials, right? You will see cases where it is not really directed against the government agency, but by the head of that government agency or by an official in that agency. In that case, if the relief sought would still bind or obligate the state, then it is not merely a suit against the public official, it is a suit against the state. And then lastly, you have to ask whether the judgment would require the state to perform an affirmative act, such as paying damages. Okay? So if that is the case, obviously, again, that is state property, then it is a suit against the state. Okay? In the same year, another question on state immunity. So the question is, do GOCCs also enjoy immunity from suit? Now, to answer this question, we need to distinguish between incorporated government agency and unincorporated government agency. For incorporated agencies, these are the ones that have their own charters. They normally have a separate juridical personality from the state. And so they are technically not the state. And why are they created? Because they perform certain proprietary functions. Their charter generally provide that they may sue or they may be sued. So an example would be your GSIS and the local government code. Remember, the local government code is a public corporation, right? And the local government code, the Republic Act 7160, explicitly says there that local governments may sue and they may be sued. GOCCs generally perform proprietary functions, and so they since they are not exercising sovereign functions, they may be sued. Okay? They are not immune from suit. So you distinguish this with an unincorporated government branch, agency, or instrumentality. If they are unincorporated, that means to say that they are government. That is government per se. And they are performing sovereign powers, in which case you cannot sue them without the state's consent. So an example would be an AFP. There is no charter creating it, DOH, and so on and so forth. Okay. So I guess this is a rule that you have to remember. You have to ask whether they are performing proprietary functions or whether they are performing sovereign functions. Okay. Same year, again, immunity from suit. It says it extends to public officials in the performance of their official duties. And so the question is, may such officials be sued to prevent or to undo their oppressive or illegal acts? So a while ago, we said that even if the public officials are impleaded or sued in their personal capacity, we need to determine, right? We need to determine if it is really a suit against the state or a suit against that public official. Okay? So to answer this question, may such officials be sued? Okay, and the answer is yes, if certain conditions are present. And what case can you file? You can file a case of mandamus or a prohibition for them to either perform the act or to stop performing that action. Okay, so if it is a suit against a government official or employee, if it is in the exercise of their duties, determine, because you can have two government duties, right? One, in the exercise of sovereign function, and then number two, proprietary function. So if they are performing sovereign functions, they may invoke immunity. But if they're merely performing proprietary function, they may be sued also. Okay? Obviously, if what they did is unauthorized, they may be sued because they are no longer performing government work if it is ultra vires. Okay. How about for LGUs? There is here a difference. We said a while ago that an LGU per se is suable because the local government code expressly waived that immunity. However, it's different if we talk about the LGU official, right? When you talk about the LGU, you're talking about the body politic, the public corporation. Immunity was waived already. But remember that LGU officials are also governed by the CSC rules, and so they are also government officials. Therefore, distinguish again, if the LGU official is performing official duties and they acted in good faith, they may not be sued because they are government. But then, again, if their action is ultra vires, then they may be sued in their personal capacities. The idea being, public officers are considered as agents of the state. And as such, if they are performing functions, official functions, they are also considered acts of the state. Okay? Okay. The immunity from suit extends also to other states under the principal par in parem imperium non habet. Okay, so in 2013, there was this question. The ambassador of the Republic of Cafirista, okay, entered into a contract with CBM, a private domestic company, and the work is to do maintenance work, to repair elevators, maintain air conditioning units, and electrical facilities in the embassy, okay, of the Republic of Cafirista. Okay. They allege, okay, that CBM did not perform their obligations, and so they terminated the agreement prematurely. CBM questioned the termination and filed the case in the RTC of Makati. So now the ambassador wants you to file a motion to dismiss and invoke state immunity from suit. Okay. So the question is, under these facts, can the embassy successfully invoke immunity from suit? And the answer is yes, because state immunity extends to other states, right? Foreign states. But not so. Don't jump the gun, okay? Because if it is a foreign state, you still need to determine if they are performing sovereign functions or proprietary functions. Okay? So actually, the Supreme Court made an enumeration of what are considered iure imperi actions. Later on, I'll show you a slide where this iure imperi actions were enumerated already. So the Supreme Court made it easy for us. All other functions are iure gestionis. Now, in here is the upkeep and maintenance of an embassy a purely commercial contract. Because you see here, Kafiristan entered into an agreement to repair and maintain elevators, air conditioning, and electrical facilities. Is that a contract? Yes, that is a contract. But is it a simple contract in the exercise of commercial functions? The answer is no, because the upkeep and maintenance of an embassy is part of the power for the exercise of international relations. That is not a commercial function. Okay. So here in MIA versus Court of Appeals, the Supreme Court already enumerated what are constituent functions. So by exclusion, If they are not found here, that means to say they are commercial functions. Okay? So to make it easy for you, just remember whether, ask the question, can the function be performed by a private person or entity? Because if your answer to that is yes, then that is not a purely, that's not a constituent function. When you say constituent or sovereign function or iure imperi, only the state can perform that. It cannot be performed by another private person. Okay? So for example, keeping of order, providing for the protection of persons. See, the exercise of peace and order, fixing of legal relations between man and wife, recognizing whether they are married or not, holding transmission and interchange of property, determine of contractual rights, definition and punishment of crimes. It's a purely legislative action. You cannot just leave this to private persons. Okay, administration of justice and so on and so forth. So these are constituent functions. Now, where do we put the upkeep of embassy? Where is it found here? So it's in the where is it? Is it number 8? Yeah, dealings of the state with foreign powers. Yes, so that is a constituent function. So the keeping of embassy falls along that or within that sovereign function of the state. Okay. Okay, let's go to another topic, delegation of powers. In 2005, they asked this question. So there is a proposed law, or Section 32 of the Magna Carta for Public School Teachers. It says there, a person who shall willfully interfere with, restrain, or coerce any teacher in the exercise of his rights guaranteed by this act, or who shall in any manner commit any act to defeat any of the provisions shall be punished by a fine, not less than 100 pesos, nor more than 1,000 pesos, but here, or by imprisonment. But it says here, in the discretion of the court. And so they left the determination of what they will impose to the court. So the question is the proviso granting the court the authority to impose a penalty or imprisonment in its discretion constitutional? Okay, and the answer there is no, because the fixing of penalties for criminal offenses is a legislative function and it cannot be delegated. But I guess to answer this question, we need first to clarify who delegated what to whom. Okay? So looking at the Constitution, why do we say that you cannot, what has been delegated cannot be further subdelegated? But who gave the delegation? So the rule is simple. Okay? The sovereign Filipino people are the authors of the Constitution. That's why in your preamble it says, we, the sovereign Filipino people. And to whom did they delegate the power to govern? They delegated it and divided it among the 3 branches of government. Okay? And so the sovereign Filipino people delegated executive power to the executive branch. They delegated the legislation to the legislative branch and the interpretation of laws to the judiciary. That was the delegation. And therefore, as a general rule, they could no longer subdelegate that. Okay? Parang ano yan, no? Inutos mo na nga kasi sa kanila. So we, the sovereign Filipino people, said the executive branch should enforce the law. Hindi pwedeng yung executive branch will further delegate that. No? We, the sovereign Filipino people, designed a bicameral Congress to make laws. Hindi pwedeng i-delegate ng Congress yun kasi sinabi nating sila nga ang gagawa. Okay? 2009 bar. So an act was passed to enhance the capacity of marginalized families. But there was a provision there. There was a joint congressional oversight committee that was created. But the power given to the oversight committee was to screen the list of beneficiary families that was already determined by the DSWD. So imagine this: there's a DSWD, right? A cabinet a cabinet instrumentality under the office of the president, executive branch. But then they choose who are the beneficiaries, and then these beneficiaries will go back to the joint congressional oversight committee. The oversight committee is composed of members of Congress. Okay? So the question is a grant of authority to the oversight committee constitutional? Okay, so to answer that question, we first need to distinguish the three concepts involved here. So the first one is separation of powers. It simply prohibits the encroachment of functions. Okay, so the separation of powers demarcates the three fundamental powers among the three branches of government. So I said a while ago, foreign relations is lodged exclusively in the executive branch, and lawmaking is lodged in the legislature. But because of the various concerns, the many fields of governance, it cannot be avoided that sometimes they need to share, or sometimes their powers have to overlap, to promote efficiency and interdependence. And that is where blending of powers come in. The classic example for the application of blending of powers is during budget, right? When Congress comes up with the General Appropriations Act. Now, yes, the GAA is a law, comes from Congress, but actually, you can see the interplay here of the executive branch as well. Why? It is the executive branch that proposes their budget, and then this is the one that gets passed to Congress, and obviously, it does not become a law without the president approving it. Now, if there's something wrong with it, obviously, you can go to the courts through this third power, the power of checks and balances. And this is simply to limit or control the powers of the other branches so that not a single branch can dominate. Okay? So, very hot issue. In the power of impeachment, right? So we have impeachable officers, and there's the only way, right, to bring them to justice is through the mechanisms of checks and balances. Okay, so it's the grant of the authority to the oversight committee to screen the beneficiaries constitutional. Obviously, the answer is no, because it will be repugnant to the concept, to the doctrine of separation of powers. Okay, the power to determine the beneficiaries is obviously lodged within the DSWD. It is already an executive prerogative. Okay. Okay, let's go to fundamental powers. 2022 bar. A city ordinance was passed providing for the removal of outdoor advertising materials, billboards that obstruct obstruct road signs and traffic signals. Okay. ABC Ad Agency, an owner of the billboards, one of the owners of the billboards removed by the city, filed a complaint because they said that the removal of the billboard constituted taking of private property without just compensation. So the question is, will the complaint prosper? Now, to answer this question, we need first to determine, is it really a eminent domain, an exercise of eminent domain. So you know that there are three fundamental powers, right? Police power, eminent domain, and taxation. Obviously, this is not a case of taxation, so you remove that one. But is it a power? Is it police power also? Because ABC ad agency seems to suggest that this is an expropriation, that this is an exercise of eminent domain. If that is the case, then its contention should be upheld. It should be paid just compensation. But in this case, why are they removing the billboards? The reason is general welfare, because the billboards obstruct road signs and traffic signals, meaning the billboards are or constitute hazards on the road, and therefore they have to be removed for the general welfare. So here, the answer is the exercise of police power does not require payment of just compensation. The fundamental powers of the state may be exercised simultaneously. Okay? So what's another example for this? Can you use the power of taxation as an implement of police power? Yes, no. What's the example for that? Sin taxes. Your sin taxes. Bakit sin? Because these are taxes that you impose on vices or on activities that are not beneficial. For example, liquor, cigarettes, right? So you impose taxes not to generate revenue, but to discourage people from consuming these non-beneficial products, right? Hindi ba beneficial ang pag-iinom? Pag-inom na nga lang, no? But that is the idea. It is an implement of police power because the state does not only like to raise revenue through the power of taxation, but also to prevent, right, the consumption, the excessive consumption of these products. So here, this is not purely eminent domain, but this is also an exercise of police power. Okay, 2005 bar. 3 questions. Describe the power of taxation. So how do you describe the power of taxation? You just memorize that one. The power of taxation is the inherent and sovereign authority of the state to impose compulsory contributions from individuals, properties, or businesses. Okay? And the purpose is to generate revenue. Okay. But more importantly, the question here is, may a legislative body enact laws to raise revenues in the absence of a constitutional provision? Okay. And the answer is, fundamental powers are inherent powers, and therefore, you don't really need the Constitution to exercise them. Why are we saying this? If you Control F your Constitution, you will not really find any definition of police power. You will not find a definition of eminent domain, and definitely you cannot find a description of the power of taxation. Actually, what you will find in the Constitution are limitations to the exercise of these inherent powers. What does that mean to say? It means that you can tax, you can expropriate, you can exercise police power, condemn property, even without the Constitution, because kaya nga fundamental, kaya nga inherent powers. What you find in the Constitution are limitations so that the state cannot abuse these powers. Kasi nga inherent yan, the state can exercise it whichever way it wants to. No? That's why the sovereign Filipino people put checks in the Constitution so that the state cannot abuse it. So to prove that point, for example, eminent domain. Ano ba yung nakalagay sa Constitution? No? Sabi niya doon, private property may not be taken for public use without payment of just compensation. You see how that it was couched in that provision. No? So it's a prohibition on the part of the state to take private property for public use. Di ba? If you do that, sabi dun sa constitutional protection na yun, you need to pay just compensation. Ano yung limitation sa exercise ng police power? Actually, it is the least limitable, di ba? Most pervasive power. But the Constitution says there, kailangan within the general welfare lagi, no? Within general welfare. So whenever the state exercises police power, it has to be general welfare. Okay? And then taxation, so many in the Constitution, has to be progressive, cannot be arbitrary, and so on. Okay? The fundamental powers are not found in the Constitution, but you will find limitations in the Constitution. Okay, here, 1994 bar, says the municipality of Antipolo, Rizal expropriated the property of Juan Reyes to be used as a public market. There was already an appropriation of 1 million from the municipal council, but the RTC fixed the value at 2 million. So kulang yung appropriation ng local government. The question is, what legal action can Juan Reyes take to collect the balance? And then a follow-up question, can Juan Reyes ask the regional trial court to garnish the municipality's account with the land bank? The answer is, pwede naman, no? Because this is a local government. No? And that's considered patrimonial property, so it can be levied. But then, if they have no patrimonial properties, you can petition for mandamus, so to compel them. Because here, there was already an appropriated amount, 1 million. Okay? So, pwede mo nang i-garnish yun kasi na-earmark na yun for that purpose. Okay? So, this is an exception to the rule that, you cannot garnish municipal funds, because in this case, there was already an appropriation. Okay? Okay, so let's go to another topic that's always asked in the bar. And my fearless forecast for this coming bar is they will ask a question on territory. So this is overdue. In 2009, there was this question that's quite confusing for a lot of bar candidates, even for some lawyers. So William is a private American citizen. He was inside the U.S. Embassy. He fought with another private Filipino citizen. Then, in front of many witnesses, he killed the person he was arguing with. Police came and brought him to the police station. William, the American citizen, protested his arrest, saying that since the incident took place in the U.S. Embassy, the Philippine courts have no jurisdiction because the U.S. Embassy are not part, the U.S. Embassy grounds are not part of Philippine territory. Technically, therefore, there was no crime committed. You know that in the revised penal code, di ba? Crimes are territorial. So, question is the contention of William correct? Okay? Now, to answer that, we need first to go back to the definition of national territory. Ano daw yung what comprises the national territory? It says the Philippine archipelago. Okay? So when we talk about the Philippine archipelago, what are we talking about? It's the entire group of islands with all the waters, no, surrounding those islands. Okay. But what is confusing, no, in this particular question is, sabi niya kasi dito, William argued that the Philippines has no jurisdiction. Okay? And you know that territory is different from jurisdiction. Okay? So let's try to answer this. Is the embassy part of Philippine territory? The answer is yes. Why? Because the national territory comprises the Philippine archipelago. Right? The U.S. Embassy is still within the Philippine archipelago. Okay, but do we have jurisdiction over that person? My answer is yes, we do, because William is not a diplomat. He doesn't have immunity. That's why if you look at, if you go back to the facts, it says here, William is a private American citizen. I think the examiner here wanted you to see that he is not a diplomat, that he cannot invoke immunity, that you have jurisdiction over him, right? But let's say they change the question here. Do we have jurisdiction over the embassy? And the answer is no, because according to the Vienna Convention on the Law of Diplomatic Relations, a foreign embassy, no, the host state, the receiving state, has no jurisdiction over the embassy of the sending state. Okay? So magkaiba yun. While it is part of our territory, we do not have jurisdiction there. Okay? But I want to explain to you that since it is part of our territory, there is a crime, no? Because crimes are territorial in nature, yes, there was a crime committed, but whether or not we will have jurisdiction would depend on whether that person is immune from suit or not. In this case, since William is a private citizen, he's not immune, we can exercise jurisdiction. But can the police enter the embassy grounds? Can the Philippine law enforcement agents enter the embassy grounds? The answer is no. We do not have jurisdiction there. Okay? So they will have to surrender him. Right? So the embassy is still within Philippine territory, but as to jurisdiction, we do not have, generally, we don't have jurisdiction over embassy grounds, no, under international law. Okay. I hope you get the distinction here, because I think this will be repeated. Okay. Okay. So let's go to another topic that is quite confusing. So in 2016, there's this seemingly very, very simple question asking you to define the archipelagic doctrine of national territory. The question calls for the rationale of that doctrine and how it is implemented through the straight baseline method. So right off, this very simple question asks actually three concepts: the archipelagic doctrine, its rationale, and the implementation of that doctrine through the straight baseline method. So to answer that first, you need to make a definition. What is the archipelagic doctrine? Now, I said a while ago that this is confusing because a lot of you would recite to me immediately that provision of the Constitution. Say if I point you back to that part there. So I showed you a while ago this Article 2, Section 1 of the 1987 Constitution. And, well, I don't blame you because some books also say that this is the definition of the archipelagic doctrine. The last part of Section 1, it says, the waters around, between, and connecting the islands of the archipelago, regardless of their breadth and dimensions, form part of the internal waters of the Philippines. That is not the archipelagic doctrine. It says here, in the sentence itself, form part of the internal waters. So that section is actually a definition of what constitutes internal waters, right? So the archipelagic doctrine simply says that the archipelago must be treated as a single unified territory. And the rationale is because it's so difficult to determine the territory of an archipelago because of the scattered islands, right? So it would be easy to determine the territory of contiguous states. You only need to delineate, the boundaries. But what is the boundary of an archipelago? For example, a country like the Philippines with 7,600 islands, how do you determine the territory? The answer is you use the archipelagic doctrine. Okay? And how do you implement it? All you need to do is to draw straight baselines. That's why, implementing it through the straight baseline method. Draw straight baselines by connecting the outermost point of the outermost islands, right? And if you are able to do that, connecting the outermost point of the outermost islands until you get a shape, a single shape, then all the islands and waters embraced in that shape, no, is the archipelago. Okay? But under the UNCLOS, right, it says there that you have 12 nautical miles from the baseline as your territorial sea. Okay? So that will also differentiate between territorial sea and internal waters. Internal waters are those that are inside the strait baselines. Okay? Territorial sea is that area of water 12 nautical miles from the baseline outward to the sea. Okay? So I hope you get that. So in this illustration here, the blue, the darker blue, that outlines the Philippines is your territorial sea. And then those that are inside, like for example here, if we use this illustration, Sulu Sea and all other bodies of water there are considered internal waters. Okay? Now, why is it important to distinguish that? Because of sovereignty and sovereign rights. You have sovereignty up to the territorial sea. That is your territory. But you only have sovereign rights, no, beyond your 12 nautical mile zone, up to 200 nautical miles. Okay? So let's review the maritime zones under the UNCLOS. This was asked in 2009. It says, explain your answer in not more than 2 sentences. Under the archipelago doctrine, the waters around, between, and connecting the islands form part of the territorial sea of the archipelagic state. So dito pa lang nakita niyo na yung mali, ano? It says, form part of the territorial sea. That's wrong, right? Sabi natin kasi, the waters around, between, and connecting the islands are internal waters. Okay? So let's review the maritime zones. You draw a straight baseline connecting the outermost point of the outermost island. And what is that point? That is the point where the water meets land. Kaya baseline ang tawag natin, no? Kung saan nagsalubong yung tubig tsaka yung lupa. Okay, so you draw that baseline there and you draw straight baselines. Everything inside it, internal waters. 12 nautical miles beyond that is your territorial sea. The territorial sea is considered as similar to your landmass. Kaya nga archipelago doctrine, single territory. Okay? And then you have 24 nautical mile contiguous zone. Do you still have sovereignty there? The answer is no, but you have sovereign rights. No? Ano mo yung kaibahan? Sabi natin sovereignty is full and plenary powers. So up to your territorial sea, you can enforce criminal laws, civil laws, administrative laws. But beyond the 12 nautical mile zone, up to 24 nautical miles, anong pwede natin gawin doon? You can have protective jurisdiction. Anong klaseng jurisdiction meron? To protect, for example, your immigration laws, no? Because that's where they could smuggle undocumented aliens. Fiscal laws, that's where they could launder, they could bring in or bring out prohibited sums of money. You can have enforcement and protection of sanitary laws, di ba? They could dump toxic, hazardous chemicals, trash in the contiguous zone, and immigration laws. No, that's where that's where they smuggle people. No, you do human trafficking, etc., etc. Okay, so sanitation, fiscal. You have immigration and customs laws. By the way, now in customs, they could bring in goods that are not taxed or subjected to tariff impositions. yun, sovereign rights na lang doon. Wala kang sovereignty. Sovereignty, full and plenary. Sovereign rights, yun na lang yung because the international law gives you those powers. Okay, so yan. Up to 200 nautical miles. Bakit? That's the third maritime zone, your exclusive economic zone. And what rights do you have in your EEZ? You have the right to use all living and non-living things that you can find up to 200 nautical miles from the baseline. Okay? So those are your maritime zones. But there is it could be extended. This could be extended, and it's called the Extended Continental Shelf, or the ECS. Why am I saying that? Because the Philippines was awarded an extended continental shelf doon sa taas, the Benham Rise, or what is now known as the Philippine Rise. It extends beyond the 200 nautical mile exclusive economic zone. Why? Because it is still part of our legal continental shelf. And what rights do you have there? You have sovereign rights there to use all living and non-living things in that area. Okay? So I hope we're clear on the maritime zones, but I think you need also to remember that this can be used to delineate even your airspace. So up to 12 nautical miles, that is your Philippine airspace. Planes are not allowed to pass there unless there is consent from our country. Okay, so when you ask about commercial flights, etc., obviously those are the states, the flags that they carry. They have treaties with us. They have agreements with us for them to be able to enter our airspace. Okay. Beyond that, we cannot prohibit. Why? Because beyond the 12 nautical mile zone is already international airspace. With that being said, allowed po ang navigation and overflight there. Okay? Kasi marami nagtatanong, bakit kasi nandun yung Chinese vessels? Kung part pala yung Spratly Islands, kung part pala yung Bahon Masinloc ng exclusive economic zone ng Pilipinas, why are there vessels there? And the answer is simple, because you cannot prohibit them. In those areas, they can fly and navigate freely. That's why if you're following the conflict in the West Philippine Sea, the countries that are supporting the Philippines are saying that the vessels that prohibit Philippine vessels from flying those are prohibiting the freedom of navigation. Okay, so yes, they can fly there, they can sail there, but they may not get resources there. Okay, we have the state, okay, that has that 200 nautical mile zone, has the exclusive rights to use all living and non-living things in that area. Okay, I hope this is clear. Yeah, because they might ask a question on the West Philippine Sea. Okay. Okay, let's go to another topic. This topic is always again asked in the bar examinations. Let's talk about citizenship. So, in 2006, okay, they asked this question. Emily Go, a legitimate daughter of a Chinese father and a Filipino mother, was born in 1945. When she reached the age of majority, she elected Philippine citizenship and studied law. Then he was nominated to the position of Associate Justice of the Supreme Court. However, her nomination was questioned by Attorney Juris Castillo, also an aspirant, claiming that Attorney Emily Go is not a natural-born citizen, therefore not qualified to be appointed. Now, to answer this question, you need first to determine the applicable constitution. Do not jump the gun because, believe it or not, there are still people living today whose citizenship is governed by the old constitutions. Okay? So, case in point, Attorney Emily Go was born in 1945. And therefore, what constitution should you use? Definitely not the 1987 Constitution, which was not yet existent at that time. So you use the 1935 Constitution. So I put here when the constitutions took effect. Just memorize them. Anyway, it's easy because the year is the year of the Constitution. So you only have 1935, 1973, and 1987. So all you need to memorize are the months and the day. Okay? So, in this case, is Attorney Emily Go a natural-born Filipino because her father is Chinese and her mother is a Filipino? So let's compare. In the 1935 Constitution, if your mother is a Filipino, you are Filipino only if you elect Philippine citizenship upon reaching the age of majority. In the 1973 Constitution, it was the same. But in the present constitution, either parent, if your father or your mother is a Filipino, then it doesn't matter, you are Filipino anyway. Okay, there's no more distinction, right? So Emily Go was born to a Filipino mother. Did she elect Philippine citizenship upon reach the age of majority? Yes. And so, is she a Filipino citizen? The answer is yes. Okay. But, have you thought about it? Paano nga ba ini-elect yung Filipino citizenship? What do you need to do? Okay? So, under Commonwealth Act 625, you can formally elect Philippine citizenship by filling out a form. So, it has to be in writing under oath, no? So notarized, and filed with the civil registry. Ganun pala mag-elect, ano? So there is a form that you need to execute, an affidavit, because it's under oath. And it has to be accompanied by an oath of allegiance to the Philippine Constitution. Okay? And you can also elect Philippine citizenship through informal election. This was enunciated in the case of Inre Florencio Malyare. Okay? So how do you do informal election? You do this. This happens when it is evident from the positive acts of a child born to a mixed marriage that he or she chose Philippine citizenship. That's why, what are these actions? For example, you grew up here, you chose to be schooled here, to study here, you ran for office, and so on. Okay, so those are positive acts, right? That evidently says that you chose Philippine citizenship. Okay? Now, who is a natural-born citizen? Section 2 of, Section 2 says, natural-born citizens are those who are citizens from birth without having to perform any act to acquire or perfect citizenship. Now, that's why they put in here the second sentence, because if you elect Philippine citizenship, let's say your mother is a Filipina, and you elect Philippine citizenship upon reaching the age of majority, are you performing an act to perfect your citizenship? The answer is yes. What is that act? You are electing. But then Section 2 removes the doubt, saying those who elect Philippine citizenship in accordance with paragraph 3, Section 1, yun yung election, shall be deemed natural born. So make no mistake about it. No, even if you had to perform an act, that is, you take an oath, and you execute in writing a formal election, those are acts to perfect your citizenship. Nevertheless, Section 2 says you are still a natural born. Okay, so is Emily Go natural born? The answer is yes. Okay. Another question, same year. Attorney Richard Chua was born in 1964. He is a legitimate son of a Chinese father and a Filipino mother. His father became naturalized when Attorney Chua was still a minor. Eventually, he studied law and was allowed to take the bar, subject to his submission that he could prove that he is really a Filipino. Although he never complied with that requirement. Okay. He practiced law for so many years until one person filed with the Supreme Court a case for disbarment on the ground that he is not a Filipino. So he filed with the Bureau of Immigration an affidavit electing citizenship. Noel contested it, claiming it was filed many years after he reached the age of majority. So the question is, will Attorney Chua be disbarred? So actually, the question here is he a Filipino citizen? And the answer is yes. Why? Because of the concept of derivative naturalization. Take note that in this case, it says here that his father became a naturalized Filipino citizen when Attorney Chua was still a minor. Under the revised naturalization law, minor children of persons naturalized who have been born in the Philippines are also considered citizens. Okay? Kaya derivative. So if the parent gets naturalized, then the naturalization operates also in their favor. But can you also attack this question by saying, anyway, he elected Filipino citizenship. Kaya lang sobrang tagal na, no? Because he is already a lawyer when he did that, and only because his citizenship was questioned. So is there a period? Is there a reasonable period kung kailan mo pwedeng i-elect ang Philippine citizenship? Actually, this is the court said here that it's a case-to-case scenario. No? There is no rule that says you have to do it within a certain period. The only gauge is reasonable time. Sabi, what is reasonable time is again case-to-case. Okay. Okay, 2003 bar. Miguel Sin was born a year ago. Okay, so when you're confronted with a question like this, when they say a year ago, that means your reckoning is today. Okay, so a year ago is 2024. So Miguel Sin was born a year ago in China to a Chinese father and a Filipino mother. His parents met in Shanghai, where they were lawfully married just 2 years ago, so 2023. Question is Miguel Sin a Filipino citizen? So let's examine who are citizens of the Philippines under the 1987 Constitution, because we said a year ago was in 2024, and so we used the 1987 Constitution. So, pasok ba siya sa number 1? Those who are citizens at the time of the adoption. Di pa natin alam, no? Number 2, those whose fathers or mothers are citizens. So, Chinese father, Filipino mother. Pasok ba? Yes, the mother is Filipino. And then the third is born before. He was not born before 73, so eliminate that. And then number 4, those who are naturalized in accordance with law. Okay? So let's examine this. He was born a year ago, so 2024, to a Chinese father and a Filipino mother. But the parents met in Shanghai and they got married 2 years ago. Now the question is, did the marriage divest the Filipino mother of her citizenship? Section 4, citizens of the Philippines who marry aliens shall retain their citizenship. Okay? So, doesn't matter. But so you have to examine the facts of this question, because it seems that the examiner is pointing you to the direction of answering this particular situation where they got married. So this is the answer. The mother is still Filipino regardless, no? Because Section 4 said they retain their citizenship unless they are deemed to have renounced it. Okay? So Warlito, a natural-born Filipino, took up permanent residence in the U.S. and eventually acquired American citizenship. He married Shirley, an American, and they had 3 children. In August 2009, Warlito decided to visit the Philippines with his wife and children, Johnny, 23, Warlito Jr., 20, and Luisa, 17. So while they were in the Philippines, a friend informed him that he could reacquire Philippine citizenship without necessarily losing U.S. nationality. Thus, he took the oath of allegiance under RA 9225. So ang question, having reacquired Philippine citizenship, is Warlito a natural-born or a naturalized Filipino citizen? Okay? So the law under Section 3 says, yes, you reacquire your status. So if you were initially a natural-born, you become natural-born. I mean, you retain that same status, okay, when you reacquire your citizenship. Natural-born citizens who become citizens of the foreign country shall retain their Philippine citizenship upon taking the oath of allegiance. Okay. So pwede, no? What does it mean? Kasi nga, sabi natin kanina, no? If you perform an act to perfect or acquire your citizenship, you are not a natural born. But this one, explicitly, the law says, you reacquire your natural born status, no? Regardless, kahit na nag-take ka ng oath. Now, here, follow-up question. With Warlito having regained Philippine citizenship, will Shirley, the wife, the American wife, also become a Filipino citizen? If so, why? If not, what would be the most speedy procedure? Let's say Shirley really wants to become a Filipino citizen also. So the answer is no. Shirley will not become a Filipino citizen because unlike in naturalization, no, where you can say that there is derivative naturalization, the wife and the minor children, in reacquisition of citizenship, only the unmarried child below 18 will benefit from the reacquisition. So, the wife is not included. So, there's a follow-up question. What is the most speedy procedure? What she can do is, she can apply for naturalization under CA 473. Okay? For as long as she does not have the disqualifications. Okay, another follow-up question. Do the children, Johnny Warlito Jr. and Luisa, become Filipino citizens? We explained already that derivative citizenship is extended to the unmarried child who is below 18. So only Luisa is qualified here because she's 17. Johnny is 23. Warlito Jr. is already 20 years old. Okay. Okay, so let's proceed to the legislative, executive, and judiciary branch. Okay, 2017 bar. Wala yan. Section 26, paragraph 2. No bill passed by either house shall become a law unless it has passed 3 readings on 3 separate days. Okay. Is there an exception to the provision? Yes, nakalagay doon, except when the President certifies to the necessity of its immediate enactment. So that is called, that is what is known as the certified urgent, no? The bills that are certified as urgent. Okay. 2010. Ito, I think there will be a question on legislative inquiry. I think they will ask this. Long overdue na rin to eh. I believe they will ask a question here. So in 2010, ito yung tanong, the House Committee on Appropriations conducted an inquiry in aid of legislation into alleged irregular and anomalous disbursements of the CDF and the CIA. Okay. And there was a whistleblower, ex-division chief of the DBM. So they implicated high officials of Malacanang. The House Committee summoned X. Okay. But X refused to testify. The DBM secretary, on the other hand, appeared, but he refused to testify, invoking executive privilege. The question is, may X be compelled to appear and testify? If yes, what sanction may be imposed on him? So, Section 21 talks about inquiries in aid of legislation. Sabi rito, Senate or House or any of its committees. Tingnan nyo yun kasi there was also a bar question saying that or asking if it was proper because only the Blue Ribbon Committee conducted the inquiry. And your answer is in Section 21. Pwede yun. Hindi kailangan plenary. They can summon people even in the committee level. Okay? The only limitation there is, so you see here in Section 21, they did not really distinguish. They can call anybody. Pero ito nga, yung limit is the rights of persons appearing in or affected by those inquiries shall be respected. What are the rights of persons attending inquiries in aid of legislation? Obviously, they have the right against self-incrimination. So they can invoke that, the right to privacy, and so on. Okay? But Section 22 is different. Section 22 talks about inquiries in the exercise of oversight function. Ito yung mga ginagawa ng Congress, no, to determine if the laws are being faithfully executed. No? In here, they may summon, kasi nga enforcement ng laws yung tinitingnan nila, they may summon heads of departments, okay, under the executive branch. But look here, it has to be with the consent of the president. So, can the president prohibit his cabinet from attending? The answer is yes, no, but only in an inquiry in the exercise of oversight function. They can invoke separation of powers there. Okay? So yun in a recent case decided by the Bank, where officers of the Pharmaly, you remember Pharmaly? Ito yung mga those who provided the PPEs during the pandemic. Their executives were jailed for refusing to answer questions. What did the court say? Sabi ng court, medyo may overreach doon. They should be released because they were not afforded due process. Okay? Sabi ng Supreme Court doon, while they cannot refuse attendance, if they do attend, their rights must be respected. Okay? Okay. Okay, so the two types of legislative inquiries. Inquiry in aid of legislation to gather information to craft, amend, or review laws. Okay. So look, Congress and its committees, pwedeng committees. And there is no distinction. Any person, sabi niya, including executive officials, private individuals, and entities. Okay. But dun sa isa, inquiry in the exercise of oversight function, the purpose is to monitor, review, and scrutinize the implementation of laws, okay, and to gauge the performance of the executive branch. So it primarily involves heads of executive departments. Okay, so they may appear with the president's consent. Okay. Okay, take note of the case of Senate versus Executive Secretariat. In that case, sinabi na they may invoke executive privilege kasi that hearing is not a hearing in aid of legislation, but a hearing in the exercise of oversight function. Ano ba yung pinag-uusapan doon? Yung pinag-uusapan doon yung implementation ng Bayanihan Heal as One law. Okay? So in their oversight function. Okay. So yung pala yung tanong, is the budget secretary shielded by executive privilege? So pwede silang ma-contempt if they do not appear, if they refuse to answer. Pwedeng contempt. But the Supreme Court said the power of contempt must be exercised with caution also, and so due process must be followed. So, bago ka ma-contempt, dapat ipaliwanag sa'yo bakit ka i-contempt. Ano yung ginawa mo? Okay? Hindi yung, because in that case that I mentioned to you, the Farmally case, allegedly they were not able to attend, but they were able to show, the respondents were able to show, na hindi naman kasi napadala sa kanila. So, there was really no notice. And then when they were not appearing already, biglang sinabi na lang na contempt na sila. Okay? So the Supreme Court said that's unfair. They were not afforded due process. Okay, ito. Then this is, I don't know if they will ask this, but they might. I'm saying I don't know if they will ask this kasi mukhang burning issue. And sub judice pa nga eh. But not really, because this has been asked several times already in the past bar exams. 27, tinanong. Section 3, Article 11 of the Constitution states that no impeachment proceedings shall be initiated against the same official more than once. So ito yung bar, no, yung 1-year bar sa impeachment. Ang tanong, isipin nyo as early as 2017, what constitutes initiation of impeachment proceedings under the provision? Di ba ito yung pinaka-issue ngayon dito sa impeachment ni Vice President Sara? Right? The gist of the Supreme Court decision saying that the impeachment complaint endorsed by Congress was within the 1-year ban. No? So invalid daw yun, unconstitutional daw yun. Di ba this is the very question? So, according to the Constitution, what are the modes of initiating? So, first is to file a verified complaint. Sino mag-file? Any member of the House, the lower house. Pangalawa, pwede rin daw mag-file ng verified complaint any citizen. Okay? Pero kailangan may resolution and endorsement ng isang member ng House. Okay? And lastly, it could be a verified complaint or resolution that is signed by at least 1/3 of the members of the House. And in this third mode, that will already constitute the articles of impeachment, and it goes straight to the Senate. Ito yung fourth impeachment complaint, no, na tinatawag doon sa issue ngayon. But let's look at Section 3, Article 11 closely. So palitan natin itong presentation para lang malinaw sa atin. Let's look at it closely. So paragraph 2, a verified complaint for impeachment may be filed. So pag sinabing may be filed, is that initiate? Yes, no? By any member of the House. Okay, so that's one. Or, another mode, any citizen upon a resolution of endorsement by any member. So hindi pwedeng yung citizen, siya lang mag-isa. There has to be a sponsor, no? So to speak. Then yung third, a vote of at least 1/3. Okay? And then the prohibition is in paragraph 4. In case the verified complaint or resolution is filed, it becomes the articles of impeachment, and therefore a trial can proceed. Now, when, so was it therefore deemed initiated? Ito, no? 2024 bar. In June 2024, Karina, a private citizen, very recent, filed a verified impeachment complaint against the Vice President. Okay. In July 2024, the House approved the report dismissing the complaint due to the absence of a resolution or endorsement. In August 2024, a party list representative filed a second verified impeachment complaint based on the same facts and ground. In September 2024, second impeachment complaint was referred to the Committee on Justice. VP moved to dismiss, arguing that no impeachment proceeding can be initiated more than once within a period of 1 year. So ang question, may the second impeachment complaint be dismissed for violation of the 1 year bar rule? So, when is it deemed initiated? Ito nga yung tanong, no? Kaya sabi ko sa inyo, parang sub judice. Kasi tignan nyo ang nangyari dito. June, okay, a private citizen filed a complaint. Okay. So what's wrong with that? What's wrong with what she filed? Ang mali, walang nag-sponsor, no? She's a private citizen. He filed it directly, no? And the complaint was referred to the committee. So the committee in July approved the report of the committee saying that it should be dismissed because walang resolution or endorsement ng member of the House. And then there was a second complaint na na-initiate. So, ito bang August 2024 barred na? Now there are two answers here kasi, no? And I guess if you answer any of that, you will be given a full point. So the first answer here could be no, it is not covered by the 1 year bar because the first complaint is null and void. Bakit null and void yung first complaint? It was not sponsored. It was not endorsed by any member of the House. Okay? And then the second answer is, yes, the first complaint was initiated. Why? Because if we go back to the provision of law, sabi niya it may be initiated by a private person. So if you look at the three modes, it may be initiated by a private person, it may be initiated by a member of Congress, or it may be initiated by 1/3 members. No? Parang lumalabas doon na yung referral to the committee is just another step, right? But what do we know? Di ba? Nag-motion for reconsideration sila ngayon. Okay. Let's go to presidential immunity from suit. 2018 bar. Will the president's immunity from suit continue even after his term has ended, considering that the events covered petition took place during his term? Okay, so the rule is president is only immune from suit while he or she is sitting. After his or her term, immunity may no longer be invoked even if the acts happened during his incumbency. Very important, you will not find presidential immunity from suit in the Constitution. This case, no, Bayan Muna versus President Gloria Macapagal Arroyo said that it is so well understood that even the framers of the Constitution did not already see the need to state it in the Constitution.
Why central books?
because it's the home of the best legal minds. Central Books has always been a good friend.
Shows that because it's the best bookstore here in the Philippines. No one else.
Of course, the Central Books na magandang policy.
With so many authors, with so many books that are being printed day in and day out. It has, I think, the state-of-the-art machines that can really, transform all of these books very fast.
So I want to be part of that home of the best legal minds.
Central has been very accommodating, very flexible in terms of discussing with the arrangements and all throughout the process. So
that is the reason why it is really privileged to become the author of this Central Books.
Central Books was able to establish a name in getting authors who are basically experts on their fields.
Well, they share the same passion as me, and they believe likewise in providing accessible quality education to the examinees, students and examinees, and they have produced so many authors.
Central Books is always ahead, up to date, hands-on, and very accessible to the authors.
Hands-on kayo. And you reach out to the lawyers, to the authors, and yung encouragement, and yung support, nandun talaga yung support.
Central Books really gave us the platform and opportunity to help the law students to bring out the materials for them, and encourage nila yung authors nila to create books for the students. So that's why I think Central Books is a great avenue for law practitioners, for lawyers, for judges to share knowledge to law students, and even to members of the bar.
It's just CBSI #1.
Okay, let's proceed. In 2022, they asked about martial law. So it says, after martial law was declared over Mindanao, police officers arrested Jose Maria without any warrant while shopping for groceries. Jose Maria questioned the validity of the arrest because he had no pending case and was not committing any crime at the time of his arrest. So the police officers countered that the declaration of martial law also suspended the privilege of the writ of habeas corpus. As a result, they could do arrests without warrant. Question is the contention of the police officers correct? Of course, the president, as the commander-in-chief, may call out the armed forces to prevent or suppress lawless violence, invasion, or rebellion. However, the question is, if the president declares martial law, does it follow that the privilege of the writ of habeas corpus is also suspended? And the answer is no, because the the law says he may place the Philippines or any part thereof under martial law or not suspend the privilege of the writ of habeas corpus. So it doesn't follow. There has to be a declaration to that effect also. This one is always asked, whether the president can abrogate a treaty without Senate concurrence. So in 2008, they asked if that's possible. Assume that the other country party to the treaty is agreeable to the abrogation, provided that it complies with the Philippine Constitution. If a case involving the validity of the treaty abrogation is brought to the Supreme Court, how should it be resolved? And the examiner here is trying to point you towards the direction of saying that if the president enters into a treaty, he needs Senate concurrence before it will become valid locally, right? And so, does it follow also that in the event that he wants to abrogate a treaty, he needs to go to Senate also and get their concurrence? The answer is the president can withdraw from a treaty as a matter of policy if the treaty is unconstitutional or has become contrary to provisions of an existing prior statute. However, there are exceptions to that rule. He may not unilaterally withdraw when the Senate conditionally concurred with that treaty. And in that conditional concurrence, they required also that they participate in the withdrawal. So there is an explicit requirement when they concurred with the treaty that they also need to participate in its abrogation. And then the second exception is when the withdrawal itself will be contrary to a statute or to a legislative authority to negotiate and enter into a treaty or an existing law which implements a treaty, because in that case, the president will be engaging in a sort of a legislative function, right? So in that case, he needs to go back to Senate for them to participate in the abrogation. I think this question could be asked in light of our withdrawal in the Rome Statute. Remember that President Rodrigo Duterte withdrew from the International Criminal Court, the Rome Statute, unilaterally, and that was questioned before the Supreme Court. And then these rules were laid out there also. Okay, Judicial Review 2004 bar. 1935, 1973, and 1987 constitutions commonly provide that judicial power shall be vested in one Supreme Court and in such lower courts. Now, the question is, what is the effect of the addition of this provision? Judicial power includes the courts of justice to settle actual controversies and to determine whether or not there has been grave abuse of discretion amounting to lack or excess of jurisdiction. So they're asking you to discuss and cite an illustrative case. Now, this requires you to distinguish between political question and justiciable question. You know the difference, right? Justiciable questions are those that may be brought to court. But a political question is not justiciable in that they are left to the discretion of, for example, the people, no? Or if it is a power delegated to the legislature, then they're the only ones who can deal with that. Okay. So technically, if it is a political question, then the courts cannot take cognizance of those. No? But because of the expanded judicial power, where is the expansion? That part where it says the court can determine whether or not there has been grave abuse of discretion amounting to lack or excess of jurisdiction. So in that case, because of extended judicial power, the court can look into whether the action has been or whether the action was done with grave abuse of discretion. So anong example natin dito? The rules of impeachment, no, could be a political question, or the rules of expelling a member of Congress could be a political question because it is governed by their internal rules. But then, as soon as the very members of Congress deviate from those internal rules, then it ceases to become a political question. It can become a justiciable question. And so what is the effect of the additional power? It blurred the lines between political question and justiciable question. Before, you can just say, oh, this is within our domain. It is not justiciable. But now, with this expanded judicial power, the court may still step in to determine whether that power was exercised with grave abuse of discretion. So this is another illustration. This was the 2004 bar SDO, a congressman. Before the end of his term, he inflicted physical injuries on another person in the course of a debate. He was charged. And the House Ethics Committee voted to expel him. SDO claimed that his expulsion was railroaded and tainted by bribery. So he filed a petition in court to declare that the House of Representatives gravely abused its discretion. He prayed that his expulsion be annulled and that he should be restored to his position as congressman. So the question is SDO's petition before the Supreme Court justiciable? Okay. Now you will be tempted to say that it is not, because there is a House Ethics Committee, and you know that the discipline of members of the House of Representatives is lodged solely also with the House Ethics Committee, specifically. So the answer there is the Supreme Court could not interfere with the suspension of a congressman, especially if the ground is disorderly behavior, because it is only the House that has the sole prerogative to determine if that action constitutes disorderly behavior. But like I said, with the expansion of judicial power, the political question may become a justiciable question if there is an allegation that they did not follow the procedure. So in this case, SDO claimed that his expulsion was railroaded. When you say railroaded, they made shortcuts. They did not follow the procedure, and worse, it was tainted with bribery. So what constitutes disorderly behavior is a political question, but then how they arrived at that conclusion could be a justiciable question. Okay? So to answer this, is SDO's petition justiciable? The answer is yes, because there was an allegation that the House of Representatives did not follow their own rules of procedure. Okay, so you need to define operative facts. So this is an objective type question. What is the doctrine of operative facts? It simply recognizes the existence of the law or the executive act prior to its declaration of unconstitutionality. Okay, so what it simply means is the consequences of a previously valid law cannot just be erased, ignored, or disregarded. Kaya operative fact na siya. Okay? How do we illustrate this? We can illustrate this by using that case. Now, when the Supreme Court declared that the community-wide or the Development Acceleration Fund, or program, DAP, was when it was declared by the Supreme Court as unconstitutional, there were already monies paid. There were already projects that were executed under the DAP. So instead of demolishing the bridges that were built, instead of getting the money from beneficiaries, the operative fact doctrine says that while the law was valid, the consequences, the actions done before it was declared unconstitutional should be respected. So we leave them be. Kaya operative fact na yan, sabi, no? We leave them be so that they can produce so that they will no longer be returned, they will no longer be destroyed. Okay, let's move on to the Bill of Rights. Okay, so here, due process 2022 bar. Pursuant to a law ordering the fixing of just and reasonable standards, classifications, regulations, practices, or services to be furnished, observed, and imposed by operators of public utility vehicles, the LTFRB promulgated and published a regulation that no car beyond 6 years shall be operated as a taxi. So the operators assailed the validity of the regulation, saying that procedural due process was violated because they were not asked for position papers. So what do you think? Were they denied procedural due process? So what you're thinking of here immediately is administrative due process, right? But not really, because what was done by the LTFRB here was in the exercise of their quasi-legislative powers. So, ang ginawa nila rito is yung kanilang power to do subordinate legislation. And in the exercise of quasi-legislative powers, the submission of position papers are not essential. Okay? So you compare this with procedural due process na ang sinasabi, you need to be given the opportunity to be heard. Now, take note that the LTFRB rule, no car beyond 6 years, is not really an investigation. Okay? It's not an investigation. And so the taxi operators are not, it's okay not to give them the opportunity to submit position papers. So the question is, how do we comply with due process when we issue regulations like this in the exercise of quasi-legislative powers? We comply with due process here by causing the publication of the regulation. Yun na po yung notice. No? Remember that there's a huge difference in between due process in judicial proceedings. It's very strict, di ba? Versus due process in administrative or procedural due process. No? But again, the question here does not really call for procedural due process, no, when you are under investigation, but in the exercise of quasi-legislative powers. So no requirement for position paper. It is enough that the rule or regulation is published. That constitutes notice already. Okay. So laging nilalagay sa syllabus to, no, yung difference ng overbreadth doctrine from void for vagueness. So you need to memorize the definitions because there's no other way to do this. So overbreadth, pag sinabing overbreadth, lagpas, no? Which means you are regulating more than what is necessary. Okay. So what is an example of a law that has overbreadth application? Let's say you want to punish incitement to violence. But in so doing, you are also preventing the right of the people to do peaceful assembly or freedom of speech. Kasi sabi mo, if you do this, you are inciting to violence. Eh paano kung nagrarally lang naman, they are just voicing out their grievances? That is allowed by law. But if the statute says that these things are not allowed and it touches other areas of protected freedoms like peaceful assembly and freedom of speech, then it will be declared as an overbreadth. Okay? Which is different from void for vagueness, because in void for vagueness, it is the language used conveys an ambiguous, no, or you don't really know what is the prohibited conduct, no? And what gauge do we use? The common intelligence, no, of men, no? So kumbaga sa Tagalog to, gets mo ba, no? It becomes void for vagueness kung hindi mo gets. If you read the statute at hindi mo gets, it could be declared void for vagueness. So although there is some flexibility allowed, no? Meticulous specificity is not really required for laws, for as long as gets mo, for as long as there are enough, no, comprehensible standards understood by men of common intelligence. Okay? Okay, here, equal protection. The VFA allows the taking of custody, the U.S. to take custody of their personnel who is subject to a criminal prosecution before the Philippine courts. Okay. Now, this is being questioned because according to the okay, according to the petitioners, it violates the Equal Protection Clause to the extent that it allows the transfer of the custody of an accused to a foreign power. This is not being afforded to other persons similarly situated. Sabi niya kasi yung mga iba, they get to be jailed in the ordinary detention centers. So you're being asked to rule on the challenge. So yung clause ng equal protection, ang sinasabi niya lang, nor shall any person, di ba, be denied the equal protection of the laws. Kaya nga clause, no? But it simply means no person or class of persons shall be deprived of the same protection. Okay? But take note that they have to be of the same class, and in the same place or in like circumstances. Now, stated otherwise, therefore, you can treat persons differently if they are not similarly situated. No? Pwedeng iba yung treatment mo sa ibang tao if they are not of the same class. Okay? So what do you need? All you need to have is valid classification. Remember our cases, very old cases like the case of Kayat, no? People versus Kayat, where an Ibaloy, no, an indigenous person was not allowed to drink imported liquor. So sabi niya, bakit yung mga ibang Filipino pwedeng uminom ng imported liquor, ng A1 gin? Bakit yung katutubo hindi pwedeng uminom ng ganon? Because of valid classification. The Supreme Court said that the rest of the Filipinos can tolerate imported liquor versus that indigenous person who cannot tolerate that liquor, and therefore, it causes them to lose control, no? Or to become rowdy, no? So yun, pwede basta meron kang classification. Okay? So substantial distinctions which make for real differences which are not arbitrary or unreasonable. Okay? So the answer here is there a distinction between a US personnel, no, who is being tried for a crime and an ordinary citizen? The answer is yes, no? Especially so that they are participating in this treaty, the Visiting Forces Agreement. Okay? Okay. Equal protection still. The Gay, Bisexual, and Transgender Youth Association, GBTYA, an organization of gay, bisexual, and transgender persons, filed for accreditation in the COMELEC. COMELEC denied the application on the ground that they espouse immorality, which offends religious dogmas. So GBTYA challenges the denial of their application based on moral grounds because it violates their right to equal protection of the law. Okay, question. What are the three levels of tests that are applied in equal protection cases? So there are three, no? And which one of the three should be applied to the case? Okay, 2015 bar. The three tests are the following. The rational basis review. Okay, so these actions, these classifications enjoy the presumption of constitutionality for as long as it is rationally related to the government interest, no? So yung action must be rationally related to government interest. Ano kaya yung mga yon? For example, they want to segregate, they want to determine if there are certain rights that should be granted to Filipino citizens and non-Filipino citizens. And what is the objective? Probably the objective is to prevent foreigners from taking the jobs of Filipino citizens. It will be used, the rational basis test will be used because what is the objective of classifying them based on nationality? Kasi nga, protectionist government, protectionist economy. Ayaw natin na mawalan ng trabaho yung mga Filipino. Yeah? So, yes, we'll look at it under the lens of rational basis review. So, ano yung pinagagamitan ng rational basis review? The usual suspects, no, or the suspect classifications. Ano ba ang suspect classifications? You have 3: race, nationality, and religion. No? So if the discrimination, if the distinction is based on race, nationality, or religion, we use rational basis review. And then the second one is intermediate scrutiny. Intermediate scrutiny meaning medyo mas mataas na yung pagtitreat, no? Because medyo ano na to, no? Medyo merong parang biases na, no? So it requires heightened security but does not involve fundamental rights yet. And saan natin ina-apply ang intermediate scrutiny? Sa mga tinatawag na quasi-suspect classifications. What are quasi-suspect classifications? Those that pertain to gender and legitimacy. Okay? And the last one is strict scrutiny because this interferes with fundamental rights and basic liberties already. No, they have to be examined more under the lens of strict scrutiny. Ano ba yung mga example ng nag-interfere na sa fundamental rights? Yung mga anything that affects life, liberty, or property. Kailangan strict scrutiny niya. Okay? So, which of the 3 levels of test should be applied to the present case? We're talking about gender, and so the intermediate scrutiny test. Okay? Okay. Okay, dito na tayo sa mga search and seizure. So there's 2002 bar, one day a passenger bus conductor. So passenger bus conductor ang nakakita ng handbag. Okay? When he opened the bag, he found a calling card ng nakapangalan Dante Galang, his own address, a few 100-peso bills, and a small plastic bag containing a white powdery substance. So he didn't know what it was. He brought it to the NBI for examination, and it was determined to be shabu. So Dante Galang was called by the NBI. He admitted that he owned the bag and the contents, but he said that the plastic bag and its contents are inadmissible in evidence because they were the product of an illegal search and seizure. So how do you decide this case? Alam nyo na to, no? Dapat, no? Article 3, mostly those proscriptions are against state abuse. Okay? Therefore, they may only be invoked against the state to whom the restraint against arbitrary and unreasonable exercise of power is imposed. So, to answer this question, sino ba yung nakahanap nung bag and its contents? It was not any law enforcement agency or agent, but a passenger bus conductor, a private person. And so, the exclusionary rule does not apply to him, no? Bakit ba kasi kailangan i-invoke natin yung proscription against unreasonable search and seizure against government? Because this could be abused by government, no? Kaya binibigyan natin ng limit, no? Kasi takot na nga tayo sa police, takot na nga tayo sa law enforcement agencies. If we do not limit how they can search or arrest persons, then a lot of our liberties will be could be subject to abuse. Okay, so in this case, as supported also by the case of People versus Marty, that drugs are admissible and they cannot be excluded because they are not the product of illegal search and seizure. So I will decide in favor of are against Dante Galang. He even admitted, no? Okay, but to answer any question on search warrants or warrants of arrest, you have to view it this way, okay? Article 3, Section 2, sabi niya, the right of the people to be secure in their persons is the general rule, okay? Kaya pag may question tungkol sa warrant of arrest or search warrants, ang lagi niyong tatanungin, ano bang ginagawa niya? Because the general rule is, all people, no, have the right to be secure in their persons, houses, papers, and effects. Okay? If you are merely crossing the street, can you be arrested? No. If you are merely sitting, can you be arrested? No. If you, di ba yung isang example pa, he was sitting on the edge of a bed without a shirt on. Ask yourself, bawal bang umupo sa gilid ng bed na walang suot na pangitaas? Right? He was crossing the street. He was sitting on a jeepney. May ginagawa ba siyang masama? If the answer is no, then he could not be arrested. That is the rule. Yeah, that is the general rule. What is the exception? Actually, the exception is when they get a warrant. Okay? Pag wala kang ginagawa, hindi ka pwedeng arestuhin. Pero kahit wala kang ginagawa, kung meron silang warrant of arrest, then pwede ka nilang arestuhin. Okay? And then, there are exceptions to that exception. If they do not have a warrant, you can be arrested anyway if warrantless arrests, no? Or if warrantless arrest is available. For example, ito nga, arrests in flagrante delicto. But please illustrate this in your head. Mas madali kasi ito pag nai-imagine nyo, no? So ito nakalagay, when, ang crucial dito, in his presence. Okay, the arresting officer must be there because in his presence. Okay? Kaya nga, flagrante delicto. Ano ba ibig sabihin ng flagrante? It relates to fire, no? Kaya it's happening, no? It is afoot, no? When in his presence, the person to be arrested, number one, is actually committed. Ginawa na niya, has committed, is actually committing, ginagawa, or gagawin pa lang in your presence, in the presence of the arresting officer, no? Which is different from a hot pursuit arrest because in here, the crime has just been committed. Okay? Tapos, meron siyang personal knowledge of the facts or circumstances na yung taong hinahabol niya could be the person who committed it, no? And in here, take note of the different kinds of probable cause. By the way, isulat nyo na ngayon. There's a probable cause for applying for a warrant, di ba? Either to search or to arrest. May probable cause ng finding kung pwedeng i-file yung case or hindi. May probable cause, no? Yan, tungkol dito. Kung hot pursuit arrest ba yan? And then there's another probable cause. Yun yung totality of circumstances when when law enforcement agents can effect yung mga warrantless arrest or searches also. Okay? So take note of the different kinds of probable causes. And then the last one is a arrest of a fugitive. Okay? So yun yung mga exceptions. And then, sa search naman, ganun din. General rule, people have the right against unreasonable searches and seizures. Ang exception, kung meron kang search warrant. Okay? And then the exclusionary rule says that if you violate those provisions, the evidence that you get will be inadmissible anyway. And take note of this. Not only in the criminal proceeding, it says here, for any purpose and in any proceeding. So question, sir, kahit labor case? Yes. Sir, kahit iniimbestigahan lang ako ng kumpanya ko? Yes. Because in any proceeding yung sabi niya dito, the evidence will be excluded. Okay? What are the exceptions to that? You may be searched without a warrant if any of these 8 circumstances are present. Okay? Consented searches, I think the most important thing you have to remember pagdating sa consented search is talaga bang nag-consent? And we have jurisprudence now that says it's difficult to appreciate consented search pag ang nagsisearch ay police or law enforcement agent. Bakit? Excuse me. Why is it difficult to gauge that? Because sabi ng court, takot naman talaga tayo sa law enforcement agents. And so it's difficult to say if we consented or we were just petrified. No? The court said, minsan nga hindi ka lang nagsalita, no? And then they will consider your silence as consent. The court said no. The consent must be overt, no? It must be expressed, right? Because sometimes because of our fear of law enforcement agents, we just keep quiet. Okay. The number 2, searches incidental to a lawful arrest. Okay, take note of the sequence here. You must first be lawfully arrested. Ano yung mga lawful arrest? With a warrant and then warrantless arrest. It cannot be the other way around. Sinearch ka muna tsaka ka inaresto. Hindi Okay? Kailangan na una yung lawful arrest tsaka ka nagkaroon ng warrantless search. And then, searches of moving vehicle, yung mga checkpoints, right? The important thing to remember about searches of moving vehicle is they cannot do an extensive search. Ang pwede lang nilang gawin is a visual search. No? They cannot even extend beyond the vehicle. So they can shine a light, but definitely they cannot use a stick or their hands to pry open anything. Okay? Or to move anything inside the car. Kailangan yung nakikita lang nila. Okay, in relation to that, ganun din, seizures of evidence in plain view. Plain view meaning you can see it. Okay, and then number 5, searches incident of inspection, supervision, and regulation sanctioned by the state in the exercise of its police power. So there was a case decided by your bar chairperson where this watercolor manufacturing company questioned the inspection or the entry of the plant, saying that they didn't have any warrant, search warrant. Now, in that case, the inspection and seizure of the obnoxious materials, products, were declared to be valid because of the exercise of the state's police power. And then number 6, customs searches, because of the very nature of the what's happening here. A person who brings in products can easily just disappear, no? And so because of the circumstances, a search may be conducted without a warrant. And then of course, the most controversial of all of this is stop and frisk searches, or the Terry searches. Later on, we'll discuss that. And finally, searches under exigent and emergency circumstances. These are the ones that were described by jurisprudence as valid warrantless searches. Okay. So let's look at an example. This is a bar question. So a police officer saw Harvey urinating in public. There is an ordinance that imposes a 500 peso fine for urinating in public. So then in there, the police officer arrested Harvey and brought him to the police station. At the police station, he was frisked and was found to be in possession of an unlicensed revolver with live ammunition. So he was charged with illegal possession of firearms. When the prosecution offered in evidence the firearm, Harvey objected on the ground that that was the product of an illegal search and seizure. Prosecution contended that the pieces of evidence were lawfully seized under a valid warrantless search incidental to a lawful arrest. So, question, was the search and seizure valid? Okay. How do we answer this? So first, we need to look at their contentions. Sabi ni Harvey, illegally obtained because they didn't have a warrant to search him. The prosecution, on the other hand, says they didn't need a warrant because he was lawfully arrested. Okay. Section 5, Rule 113 of the Revised Rules of Criminal Procedure enumerates nga, no, the when a valid warrantless arrest may be done. Now, does it fall under any of those? Was Harvey caught in flagrante delicto? Did he commit a crime? And based on the personal knowledge of the police officer, he was the perpetrator of the crime. Now, the question here is, and then the third, is he a fugitive? Definitely not. No? Is urinating in public a crime? Hindi. And here, the question itself volunteered the answer. Urinating in public is only punishable by a fine. 500 peso fine lang. Okay? So, what is the answer to this question? He was not lawfully arrested because his act is only punishable with a fine. So that is your case of People versus Cristobal. No? In People versus Cristobal, the Supreme Court said that a person is not under arrest if he is stopped for a violation which is only punishable by a fine. Okay? But when you are confronted with these types of question, you need also to determine if he was arrested by virtue only of that particular act. So here, he was urinating in public. So, can he be arrested for urinating in public? Sabi nga dito, hindi kasi fine lang. Okay? And a while ago, I told you, if it is a search incidental to a lawful arrest, we need to find out first if he was lawfully arrested. Okay? May warrant ba sila? Wala. Does it fall under any of the exceptions? Hindi rin. So, hindi pwede. Okay? Okay. Another case, Ernesto, a minor, was driving a motor vehicle. He was stopped at a mobile checkpoint. SPO1 Jojo noticed that he is a minor, so he asked him for his driver's license. Ernesto wasn't able to show any. So the police officer requested Ernesto to alight from the vehicle. And when he went down from the vehicle, the police saw something bulging in the pants of Ernesto. May nakaumbok sa pants ni Ernesto. Okay? And so the policeman frisked him, kinapkapan, and saw a caliber 22 pistol. Okay? So he was arrested, detained, and charged. At the trial, Ernesto argued that the policemen at mobile checkpoints are not empowered to conduct nothing more than a visual search. So they cannot order the persons riding the vehicle to alight, and they cannot frisk or conduct a body search of the person or the driver or the passengers of the vehicle. So the lawyer said that the search was illegal, and therefore anything, that even the gun, is a fruit of the poisonous tree, and they're claiming the exclusionary rule. Okay. So, tama ba sila? Tama ba? This is a mobile checkpoint. Okay? So, is a mobile checkpoint an exception to the rule on searches without warrant? Yes. No? Pero, how were they able to get the evidence? Pinababa kasi siya. No? Pinababa siya. So is that allowed? The rule is the search is limited to a visual search, and the occupants should not be subjected to a body search. Okay? Now, is it therefore a search incidental to a lawful arrest? Pwede ba nating ma-justify doon? Hindi rin. Okay? If at all, Ernesto could be charged with a violation of an LTO an LTO prohibition, no? So ganun din, no? Punishable by fine only. So, let's look at some cases that illustrate the totality of circumstances to explain also the stop and frisk rule. Now, yung stop and frisk or the Terry rule, no? Alam niyo na to, no? Yung if you are the law enforcement agencies can pat, no? Pwedeng tapikin, pwedeng kapkapan yung outer clothing to determine if you have weapons that could hurt them or you or other people. Okay? But ito, merong ginamit yung Supreme Court na phrase, no? Totality of circumstances. And the rule is, the arresting officer, kaya nga may probable cause, no? The arresting officer should have personally observed at least 2 or more suspicious circumstances, the totality of which will lead to a probable cause. Okay. So in Manalili versus CA, ano daw yung mga circumstances? Number 1, the accused had red eyes. And then, susuray-suray siya. He was wobbling like he was drunk. Nasan siya? Nasa sementeryo. And then that cemetery is reported to be a place where illegal activities are happening. Okay? So, collectively, ang tanong, bakit kasi siya nandun, namumula yung mata, parang lasing, and andun siya, papalaboy-laboy siya dun sa sementeryo. So these things put something in the mind of police officers that maybe up to no good. No? In People versus Solaya, the accused and his companions were making drunken actuations. Ano kayang itsura ng making drunken actuations? Ano bang itsura ng mga lasing? No? But here's something that's telling. When his companions saw the police, they ran away, they fled. And why were the police officers there? They were on a legitimate mission to verify reports that armed persons were roaming the vicinity. So, totality. Then in Palencia versus People, the accused was checking out some plastic sachets in his left hand. Okay? Nung nakita niya yung police, tumakbo siya. And then, where he was is a place notorious for the trade of dangerous drugs. Okay? So, in these circumstances, the Supreme Court allowed the search of these people because of probable cause, the totality of circumstances. Okay? May follow-up question tayo dun kay Ernesto. Okay. The arrest made as a consequence of the invalid search was likewise illegal because the unlawful act cannot be made the basis of a lawful arrest. Kasi kinapkapan nga siya, may nakitang baril. Okay? The basis of the arrest was the discovery of the unlicensed firearm. However, because the search was invalid, the warrantless arrest was also invalid. Okay? So it will be excluded and his arrest will be declared as illegal. Okay, a witness dito si A witnessed 2 hooded men. So may nakita siya na dalawang naka-mask, no? With baseball bats. They saw them enter the house of B. Okay. After a few seconds, may narinig sila. B, they heard B shouting, "Wag po, wag pilo, babayaran kita," sabi niya. Then A saw the 2 hooded men hitting B until he fell lifeless. The assailants escaped using a yellow motorcycle with a fireball sticker, so very specific, toward the direction of an exclusive village. A reported the incident to PO1 Noval. Following day, PO1 Noval saw the motorcycle. The next day na to, nakita ni PO1 Noval, yun yung motor na merong fireball sticker. Okay? In the garage of a house at Santa Ines Street. Nagtanong siya, Tapos pinagbuksan siya ng caretaker. Tinanong niya yung caretaker, sino may-ari niyan? Sabi ng caretaker, sina Pilo at Ramon Maradona. But they're not here right now. So, PO1 Noval insisted to get inside. Out of fear, natakot yung caretaker, they allowed the PO1 Noval to get in. At nakita ni Noval 2 ski mask, 2 bat katabi ng motor. A question, was the search valid? And what about the seizure? Okay. The warrantless search was also invalid. Bakit? Now, does it fall under any of the exceptions? Unang-una, no, wala namang personal information yung police officer. No? Number 1, hindi naman niya nakita. No? Hindi niya nakita yung incident. Pangalawa, wala. He had no personal information about what happened. It was just related to him. It was just relayed to him. He does not have any personal knowledge, no? Pagka pinagtagpi-tagpi niya lang yung mga information and then sinuwerte siya na nakita niya yung motorcycle with a fireball sticker and then the mask and the baseball bats. Okay? And take note that there was a considerable lapse of time already the following day, sabi na niya, no? So hindi rin pasok dun sa hot pursuit, no? Was there a consent? It could not have been given by the caretaker because the right was not his to claim. No? The warrantless seizure is not justified under the plain view doctrine also. No? Kasi pumasok siya. No? Okay? So, excluded evidence. We cannot justify the warrantless search. Okay, here, ito yung Manalili case. No? Crack officers of the Anti-Narcotics Unit were assigned on a surveillance of the environs of a cemetery where the sale and use of drugs are rampant. Man with reddish and glassy eyes, walking unsteadily, moving towards them, but then veered away, umiwas nung nakita niya yung mga police. They approached him, introduced themselves, and asked him what he was clenching in his hand. He kept quiet. The policeman pried his hand open and found a sachet of sabu. He was charged in court and he objected to the admission of the evidence. Rule on the objection. So, pasok ba sa stop and frisk to? We mentioned that a while ago. Yeah. Can we appreciate probable cause on the part of the arresting officers? The answer is yes, no? Because 2 or more circumstances were present. Okay? So, yan. Red eyes, susuray-suray in a cemetery known to be hangout of addicts. Okay. So, there was probable cause for the police to stop and frisk him. Okay, ito, nung best bar ever. As a car driver was getting into their car inside the parking area of a mall in Makati, 2 individuals suddenly came from behind. One pointed a gun and the other grabbed the car keys. So, the 2 then took the car and sped away. Nung nahimasmasan na sila, the driver took his phone and opened the app My Car, Find My Car. So, the driver then went to the nearest police station and showed the officers the current location. Nahanap niya using GPS. 6 hours after the car had been stolen, a combined team of elite police officers from the HPG and the CIDG, by force and without a warrant, searched a private home in Novaliches. Private home was pinpointed by the GPS tracker. So the private home was enclosed by a gate and may security camera. In the private home's garage, the police found the driver's car along with 2 other cars, which matched police records of previously stolen motor vehicles. Then and there, they arrested the owner of the private home who was charged with kidnapping. Question, are the seized cars admissible in evidence? So ito, ano ba yung tinatanong dito? Hot pursuit nga ba to? Kasi ginamit, find my car. To appreciate arrest effected in hot pursuit, kailangan daw ipakita, number 1, police officers have personal knowledge of the facts based on their observation. Okay? And then, there must be the element of immediacy from when the crime is committed up to the point of arrest. Now, let's look at this. Meron bang personal knowledge of the facts based on his observation? Wala. Bakit? Ano ba yung information na binigay lang sa kanya? From the driver who used a GPS app. Di ba? Remember the case of People versus Sapla? No? A mere information na wala na siyang ibang basis cannot be used. No? Cannot be considered as personal knowledge. Okay? And then look, 6 hours after the car was stolen, is there immediacy? Hindi. They could have gotten a search warrant already. 6 hours na pwede na silang nag-apply ng warrant yan. Okay? So this was similar to the case in Adoma versus People. Okay, we only have a few more slides. Let's finish this up. Let's go to the last topic, public international law. Okay, in 2012, they asked what are the sources of obligations in international law. So the sources of obligations, they are found in Article 38 of the International Court of Justice Charter. Okay, but this 4, if you look at the reviewers, the books, they divided this into 2, the primary sources and the secondary sources. So 1, 2, and 3 are primary sources, and number 4 is divided into 2, judicial decisions and writings of the most highly qualified publicists. These are secondary sources. Okay. Number 1 is also called conventional law. Okay. Conventional law. Bakit? Kasi conventions, treaties. Okay. What is the distinction between a treaty and a convention? Technically, just the number of parties. No? Pag sinabi mong treaty, usually konti lang yan, bilateral, no? Or a few states. But if it's already a lot of states, you normally call it convention. Okay? So it can take on a lot of names. Also, conventions can be called concordats, no? Agreements, no? Pacts. But take note that this is not the same as a conference or declaration. Magkakaiba yan, no? Anyway, conventional law ang tawag dyan. Treaties or conventional law. Now, it is a good source of obligation in international law. Why? Because treaties are likened to contracts. And what do you know about contracts in domestic law? Contracts are the laws between the parties, because what is the most important element of a contract? It is consent. Okay, so we know already that in international law there's no international legislature. So where do we get these laws? We get them from here, no? From these sources. And what better proof can we get than consent, no? That they want to be bound by that. Okay? And then international customs, customary international law, okay? As evidence of a general practice accepted as law. So these customs have been used, no? Since time immemorial, no? And again and again. That's why they have been established and accepted as law. Okay? Then general principles of law. Ano ba ang general principles of law? These are unwritten laws, no, already. For example, you have yung mga concepts of good faith. Yeah. We know what good faith is, right? But there could be several descriptions, no, or definitions, but we know what it is: estoppel, prescription, and so on. Okay. And then number 4, judicial decisions. I think what is important here is the ICJ Charter did not distinguish if the judicial decision is international or domestic. Okay? So hindi kailangang decision nito ng ICJ, ng ICC, ng PCA. Okay? It may be a judicial decision of a local court. The Supreme Court of the Philippines can decide on something, and it can be a source of obligation in international law for as long as they discussed a matter that has international law implication. For example, if the Philippine Supreme Court decides a case pertaining to Filipino comfort women during the Japanese occupation, and it requires the Japan to make reparations, it has international law implications. So that could be used as a secondary source of obligation. And then the last one, teachings of the most highly qualified publicist. Take note of the superlatives being used here. Most na nga, highly pa, qualified pa, no? So has to be like that. Hindi lang pong sino-sinong publicists, right? But this is a chicken or egg situation eh. How can you be considered as most highly qualified publicist? Kailangan daw na-cite ka na ng mga international tribunals. No? So how can you be cited if you are not yet most highly qualified? But anyway, that is the requirement. 2008 bar, what are the elements of customary international law? So there are two elements, the material factor and the subjective factor. The material factor, or the general state practice, is answers the question, what is the custom? Okay? What is the custom? So, let's give an example. The rule on ano ba? Yung diplomatic diplomatic immunity has risen to the level of customary international law. In fact, it was solidified into a treaty, Vienna Convention on Diplomatic Relations. But traditionally, if a head of state visits another country, they are afforded all the niceties, all the ceremonies, because that's custom. And then what is the subjective factor there? The opinion, kaya opinio juris, the opinion or the belief that if you do this, you are in fact complying with international law. Okay? Ano pa bang example ng customary international law? Yan yung mga protocols, non-intervention is a customary international law. Non-intervention. In the case of USA versus Nicaragua, right? Even if the US did not participate in that case, the court, the International Tribunal found that the US believes in non-intervention. So merong opinio juris. Opinio juris is simply a belief on the part of a state that it is bound by the law in question. Okay. 2010 bar. The dictatorial regime of President A of the Republic of Gordon was toppled by a combined force led by General Abe, former Royal Guard, and the secessionist Gordon's People's Army. The new government constituted the Truth and Reconciliation Commission to look into the crimes committed under President A's regime. After the hearings, they recommended that an amnesty law be passed to cover even those involved in the mass killings, genocide, who opposed President A. So the international human rights groups argued that the proposed amnesty law is contrary to international law. You are being asked to decide. Genocide is an erga omnes act, meaning the punishment, and the law governing it is jus cogens already. And a jus cogens norm, because it is a peremptory norm, it is non-derogable. Okay? So, hindi pwedeng magkaroon ng mga exceptions, right? So the proposed amnesty law is contrary to international law because you cannot waive, you cannot give amnesty to someone who committed mass killings, genocide, okay? Non-derogable. 2017 bar, State A and State B enter into a 10-year mutual defense treaty. After 5 years, State A finds that the more progressive State B did not go to the aid of A when it was threatened by a strong neighbor C. So, hindi kumampi yung si State B nung nag-away sila ni State C. Okay? So, State B reasoned that it had to be prudent. Kailangan niya mag-ingat kasi it has existing trade relations with C. Question: what is the difference between principles of pacta sunt servanda and rebus sic stantibus in international law? And second question: are the principles of pacta sunt servanda and rebus sic stantibus relevant to this question? Okay. So pacta sunt servanda, actually the way to read this is continuous dapat. Pacta sunt servanda rebus sic stantibus. Ganun dapat yan eh. Bakit? Ang literal translation, agreements must be kept, things thus standing. Okay? What does that mean? No matter how hard the obligation is, you need to comply in good faith. You need to perform your obligations in good faith no matter how hard it is. But things thus standing, meaning if there is a condition, no, where there is a substantial change in the circumstances, which is unforeseen or unforeseeable, then you may be allowed to be relieved of your obligation. Okay? I like using the case of Naga Telephone Company and Naga Electric Company to illustrate pacta sunt servanda and rebus sic stantibus. So, this is a case involving an electric company and a telephone company. Before, hindi pa uso yung fiber optic. Only electric companies would install posts, no? Yung mga electric posts. Kasi sila lang naglalagay ng kuryente sa poste. Okay? But then, nung na-invento itong mga telepono, no? Meron na rin mga telephone lines. So, Naga Telephone Company requested or entered into a contract with Naga Electric for them to use the posts. Makikilagay na lang ng telephone wire dun sa mga poste para hindi na sila magtatayo ng sarili nilang poste. Okay? The agreement was for 50 years. The problem with telephone lines before, kasi hindi pa nga fiber optic, for every line, you need another wire. Ang electricity, basta may high tension wire ka na, pwede mo nang i-distribute. No? Hindi mo na kailangang paramihin yon. But for telephone wires, for every subscriber, you need one wire. E di kung halimbawa, when they entered into that agreement, halimbawa, may 20 na subscribers lang. 50 years yon. Let's say, naging 1,000 yung subscriber. Gano'n nakakapal yung mga telephone wires? Ang nangyari, nabali yung mga poste. Okay? Nagkakandabali yung mga poste. And because they are owned by the electric company, yung electric company nagpapaayos. So sabi ng electric company, nalulugi na kami. Okay? They went to court and said they should be relieved of their obligation. Okay? So why am I using that example? Pacta sunt servanda. No matter how hard it is, because you entered into that agreement in good faith, you have to comply with your obligation. But rebus sic stantibus, if there are substantial changes in the circumstances, no? Pero ang tanong ko dun, unforeseen ba yon? Nakakapal yung telephone wires? Or unforeseeable ba? That's debatable, di ba? Pero yun bang pagbigat nung when it became too burdensome for the electric company, nagkaroon na ba sila ng reason to be absolved of their obligation under a similar circumstance like rebus sic stantibus? No? Okay, so that's the difference. Are the principles of Pacta Sunt Servanda and Rebus Sixtantibus relevant to the treaty relations? Yes, they are relevant. No? Kasi international law yan. And they are, actually, they are being used to determine whether treaties between state parties should remain or they should be allowed to be absolved from any obligation. Okay? Okay, 2017 bar again. President signs an agreement with his counterpart in another country involving reciprocity in the treatment of each country's nationals residing in the other's territory. Kaya lang hindi niya pinakoncur. Okay? Is the agreement signed by the President effective despite the lack of Senate concurrence? So ito yung nabanggit natin kanina, Section 21, Article 7. No treaty or international agreement shall be valid and effective unless concurred by 2/3 of Senate. But look here, the question says signs an agreement. So executive agreement lang. Okay? We already differentiated kung ano yung executive agreement at kung ano ang treaty. Okay? 2008 bar, President alone, without the concurrence of the Senate, abrogated a treaty. Okay? Assume that the other party is agreeable. Ano na natin to, no? Pangilinan versus Cayetano. President can withdraw from a treaty as a matter of policy. Okay? And it was also in this case where the Supreme Court said that the executive branch is the sole architect of foreign relations. Okay? Ito yung isang hinahanap ko kanina nung dinidiscuss natin yung maritime zones, no? and the UNCLOS provisions on maritime zones. Okay, 2016 bar, Section 2 of RA 9522 declared the KIG and Scarborough Shoal as regime of islands. Professor Agaton contends that since the law did not enclose the islands, Philippines lost sovereignty and jurisdiction. Is his contention correct? Okay. To answer this question, we need to determine ano ba yung regime of islands. Okay? So regime of islands, they refer to the rules governing islands in terms of their entitlement to maritime zones. Only an island can generate territorial sea, exclusive economic zone, and continental shelf. So, yung maritime zones, pwede lang siyang ma-appreciate kung island. Okay? Now, how do we know if it is an island? The UNCLOS also provides that answer. It is an island if it is visible during high tide, no? Hindi siya lumulubog pagka high tide. And it must be able to support long-term human habitation. Okay? So how does it support long-term human habitation? You have to have a source of fresh water. So yung RA 9522 daw, dineclare niya yung KIG tsaka Scarborough as regime of islands. Okay? Ang tanong is, if they are a regime of islands do we draw straight baselines to connect them? Kasi ang sabi ni Professor Agaton, since hindi sila in-enclose doon sa drawing ng straight baselines, nawala daw yung sovereignty and jurisdiction natin. What is the answer? The answer is, his contention is not correct. Why? Why? Because if they are regime of islands, then they are entitled to their own maritime zones. Pwede ba tayong magkaroon ng territory outside of our territory? Yes. No? Hindi naman kailangan contiguous. No? So, in this case, we will have the Philippine archipelago as the Philippine territory. But since we declared the KIG and the Scarborough as regime of islands, they are also our territories and they generate their own maritime zones. No? So, but again, this is something I would like to discuss with you. There is a huge difference between international law and domestic law, ha? Kasi malamang tatanungin to yung in case there is conflict between domestic law and international law, which one will prevail? And your knee-jerk reaction would say domestic law will prevail over international law. But that is assuming that the inquiry comes from a domestic court. Diba? Kasi sabi ng Constitution natin, all laws, treaties, agreements, etc., must conform to the Constitution, di ba? Ano yun? Primacy of the Constitution, no? Judicial review, so that anything, no? All laws must conform to the Constitution. And so, if it is international law and it does not conform to the Constitution, our Constitution will prevail. But like I said, we are assuming na ang nagtatanong ay domestic court. But what if the inquiry is coming from an international tribunal? Do you think that your Constitution will hold water? Halimbawa, ang nagtatanong ay International Court of Justice. Do you think that the Philippine Constitution will be supreme? The answer is no. Because if there are 195 countries who are UN members, do you mean to say that there will be 195 constitutions that will govern their relations with each other? No. Okay? So, in the event of a conflict between domestic law and international law, let's determine first which tribunal is weighing them. If it is a domestic tribunal, by all means, the Constitution is supreme. But if it is an international tribunal, then international law will prevail. Okay? So here, RA 9522 is a domestic law. And the domestic law declared the KIG and the Scarborough Shoal as regime of islands. Okay? Take note of the decision in Philippines versus China, where the arbitral tribunal in that case said that the KIG and the Scarborough cannot be considered regime of islands because they are low elevation water features, and they are not visible during high tides. Okay? Tandaan niyo yun, ha? Oh. But if we follow merely, if we rely on the facts of this particular question only, pag regime of islands na sila and we assume they are, then they can still be considered Philippine territory. In fact, it will be better. You know why? Because they will generate their own maritime zones. Eh kung yung, okay, let's imagine the Philippine map, di ba? Sabi natin, ang teritoryo lang ng Pilipinas under the UNCLOS is up to that blue line, 12 nautical miles beyond the baseline. Alam nyo ba na yung KIG at Scarborough Shoal, they are far from the 12 nautical mile territorial sea already. So actually, lagpas na yan ng territorial sea. But if this law declared them as regime of islands, ibig sabihin, yung computation natin ng 200 nautical mile, easy natin, lalagpas pa. Because ang reckoning na natin is yung Scarborough at yung KIG. Okay? So I hope you got that. 2004 bar, distinguish briefly but clearly between territorial sea and internal waters. Okay? So territorial sea is 12 nautical miles from the baseline. Internal waters is inward. So ang visualization lang natin ito, territorial sea outward from the baseline, internal water inward from the baseline. Okay, 2022 bar, a foreign commercial ship was spotted by the Philippine Coast Guard dumping garbage and toxic waste. Look, the reason why they put a very specific measurement, 20 nautical miles, is because they want you to answer using the maritime zones. Okay, so 20 nautical miles from Nasugbo, Batangas, the nearest coastline of the Philippines. Officers of the ship were arrested and charged with the RTC for violation of environmental laws. Officers of the ship filed a motion to dismiss on the ground that Philippine courts do not have territorial jurisdiction since the vessel was sailing outside the territorial sea. Is the ground to dismiss correct? Ito yung sabi natin. You have sovereignty up to 12 nautical miles, but you have certain protective jurisdictions beyond the 12 nautical miles and within the 24 nautical miles. Look at this. Is it within the 24 nautical miles? Yes. No? It is the sovereign right of a state to prevent, punish violations of its customs, fiscal, immigration, or sanitary laws and regulations. Okay. Since they were dumping garbage, that is obviously a violation of our sanitary laws, and therefore we can take jurisdiction under yung protective jurisdiction, our right to protective jurisdiction. Okay. Ito, and then yung last lang na napili ko na question is 2007 bar. You just memorize what is speciality. Now, this is not specialty, a speciality and double criminality. There was, I think, 2 bar exams na magkasunod din na natanong to. Okay? So, Lawrence, Filipino computer expert, invented a virus. In May 2005, his virus spread all over the world, caused $50 million in damage to property in the U.S. In June 2005, he was criminally charged before the U.S. courts under their anti-hacker law. Assume that in July 2005, the Philippines adopted its own anti-hacker law. The U.S. has requested to extradite Lawrence. Is the Philippines under an obligation to extradite? Okay. So, ito yung mga rules ng extradition. Okay? So, number 1, the extradited individual will only stand trial for an offense specified in the extradition, and an extraditable offense must be an offense that is punishable under the laws of both the requesting and the requested state by deprivation of liberty or under detention for a maximum period of at least 1 year. Okay? Now, na-satisfy ba natin to? The answer is no. Why? Because when he was arrested, when he committed the act, wala pa naman tayong anti-hacker law. No? Tignan nyo to. May 2005 niya ginawa yung virus kumalat. No? Wala pa tayong anti-hacker law. So ano yung rule? Nullum crimen nulla fine sine lege. Diba? There is no crime if there is no law punishing it. So, hindi siya pasok sa extradition. Okay? Okay, that's it. Good luck. Yeah, don't worry. Malapit na yan. Matatapos na rin yan. So just pray. Prayers work. And then it will keep you relaxed. It will, ang hirap kung iniisip nyo na na you have to absorb all of this. No? But prayers definitely work. And so I urge you, just don't be anxious. Kayang-kaya niyan. Good luck, everyone.
Thank you, Dean Libiran, for an enlightening lecture on political law. And as I mentioned a while ago, our lecture for today for political law is just one of the many lectures for Central Book's Best Pre-Week Ever Bar Lecture Series 2025. As we also have those for criminal law, remedial law, legal and judicial ethics with practical exercises, and lastly, taxation law. Like and follow the Facebook page of Central Books to make sure that you guys are updated on the dates and the speakers for each lecture. Thank you again, Dean Libiran, for your lecture on political law, and thank you to all the participants and the viewers that attended today's lecture. Again, this is Hannah from PUP College of Law, and I will see you next time.